starting. All attendees are in listen-only mode.
Hello, everybody, and thank you for joining us today. I'm Carol Koransky, a partner here at Wilkin Guttenplan. We are pleased to bring you a second presentation of this webinar that was originally presented back in August. We know it's an important topic, and so we're glad to be able to give those of you that missed it the first time a second chance to listen. On Thursday, July 13th, Governor Christie signed legislation to enhance owner participation in community association elections. The Legislative Action Committee of CAI worked side by side with Senator Gordon, the sponsor of the bill, to ensure that the final version of the law would be balanced and not impose any undue burdens on the community associations. This was a long process, and we thank CAI LAC Committee for their efforts. There's a lot of information in this new legislation. We have three extremely qualified attorneys from Hill Wallack who are well versed in this legislation to discuss it with us today. So first, Ron Pearl, he's a partner in charge of Hill Wallack's Community Association practice in Princeton and a member of the firm's management committee. Ron concentrates his practice in the areas of community association law, construction law, transactional real estate, eminent domain, and tax appeals. He's also a mediator for construction, real estate, and community association disputes. He represents condominium association, homeowner associations, cooperative, and real estate developers. Ron's nationally recognized for his work in the field of community association law. During his term as national president of Community Associations Institute, he pursued a theme of building community and has advocated a fresh look at the role of community associations. He's been extensively involved in developer transition and construction defect litigation over the past 30 years. We also have with us Carolyn Record, who's a partner in the Morristown office of Hill Wallack, where she's a member of CAI and the real estate practice, of Community Association and Real Estate Practice Groups. She's also a member of the CAI LAC Committee. Carolyn concentrates her practice in the area of community association law and residential real estate. Her practice includes estate planning and administration, special needs trusts, guardianship applications, foreclosure, and other real estate related work. Previously, Carolyn was heavily involved in all aspects of construction defect litigation and was a representative of the steering community for community associations in the FRT plywood consolidated litigation back in the early 1990s. And our third speaker, Jonathan Katz, is a partner in Hill Wallack's Community Association Practice Group in Princeton. John concentrates his practice in the areas of community association law and litigation, representing condominium and homeowners associations throughout New Jersey and eastern Pennsylvania. John currently serves on the board of directors of the Pennsylvania-Delaware Valley chapter of CAI. He previously served as the chair of CAI New Jersey Editorial Committee, CAI Pennsylvania-Delaware Valley Communication and Content Committee, and also the New Jersey Regional Council. John's the editor of Hill Wallack's Condominium and HOA Law blog. So we have a lot to go, so let me just go through quickly the housekeeping rules. To ask any questions, please use the questions pane in the GoToWebinar dashboard on your screen. We'll try to answer as many questions as possible. We will be polling our audience in the beginning of the session. It will help us to get a sense of the participants and their experience, and we have a few other polling questions throughout the presentation. For those of you that will be getting credit through CAM, it's important that you answer the questions. We do need to know that you answered all the questions and you participated in the entire webinar, so that's important. The webinar is being recorded. It will be uploaded and it will be on our website at www.wgcpas.com. So without further ado, we'll get started. The first polling question, just so we do have a feel for who's in our audience. Who's there today? Board member, manager, attorney, or other? So you can indicate. So it looks like everybody is quickly answering that question. Primarily, we have managers, a few board members, and then some attorneys as well. So thank you, and hopefully we'll be able to answer all the questions. So we'll get started. Carolyn's our first speaker, so I'm going to turn it over to her. Thanks, Carolyn.
Thank you. Good afternoon. This webinar and the materials we are presenting are not intended to constitute legal advice, nor are they intended as a source of advertising or solicitation. Your participation in the webinar does not create or constitute an attorney-client relationship with any of the presenters. This program is presented for informational purposes only. You should obtain specific legal advice from your own attorney before acting upon the information provided. Radburn was established in Fair Lawn in 1929, almost 90 years ago, and is one of the oldest planned real estate developments in the United States. The Radburn's design was described as a town for the motor age, so that pedestrians and automobiles would be separated. The community consists of 149 acres, with approximately 650 diverse styles of homes for about 3,100 residents. In addition, Radburn also includes an extensive system of recreational areas and amenities. The community is governed by the Radburn Association, which has the standard responsibilities of establishing, collecting, and dispersing assessments, maintaining and providing services for the various parks and facilities, and interpreting and implying the requirements of the Declaration of Restrictions. The affairs of the association are controlled by a 9-member Board of Trustees, 8 of whom are elected by the membership. Not every owner in Radburn is a member. Per the somewhat unique language in its governing documents, members are defined only as the current and former trustees of the association, which is about 40 residents. The 90-year-old documents also state that the only way to be a member is to serve as a trustee. And the only way to be able to run for the board and become a trustee is to be nominated by the current trustees. Radburn also has its Radburn Citizens Association, which non-members are invited to participate in. The president of that association is automatically given one of the 9 seats on the association's Board of Trustees. The Citizens Association was created to give the non-member residents an opportunity to voice opinions and address concerns. The 3,000 non-member owners continually fought to change what they considered to be an outdated form of governance, especially in 2004 when the board sold a portion of Radburn's parkland. In late 2006, a group of residents filed a lawsuit that challenged the board's system of governance. 4 years later, in 2010, the Appellate Division of the State of New Jersey issued a decision in favor of the association and upheld the election membership procedure in place. But it did indicate that the board was required to open its meetings to all owners and disclose certain financial documents. This decision was obviously not well received by the membership within the community. So State Senator Robert Gordon, at one time had been a resident of Radburn, was consulted and introduced this legislation in September of 2016 to specifically make Radburn's election voting process more inclusive and transparent, but ultimately to make the election process more inclusive and transparent in all associations. This was not the first attempt at election reform. In the 3 prior legislative sessions in New Jersey, bills were introduced which addressed this issue. Senator Gordon's bill, which was introduced approximately a year ago, was sponsored by 7 primary sponsors and 12 co-sponsors in the Senate, and 4 primary sponsors and 2 co-sponsors in the Assembly. 2 months after it was introduced, it was approved by the Senate unanimously. And 6 months after that, in May of 2017, it was, after being amended a few times, it was approved unanimously by both the Assembly and the Senate. As stated before, on July 13, 2017, Governor Christie signed the legislation into law. This new legislation amends and is now part of the Planned Real Estate Development Full Disclosure Act, which is also known and referred to as PRED or PREDFDA. PRED was originally enacted in 1977, in part to regulate the creation, marketing, and sale of units within planned real estate developments, which were created after that time. This new legislation specifically applies to all community associations in New Jersey, including condominium associations, homeowner associations, and cooperatives, regardless of the date the association was established. Finally, and most importantly, many of the specific changes we are about to review will override any current contradictory bylaw requirements in every community association in New Jersey. Now we would like to introduce our second polling question for your response.
Okay, thanks, Carolyn, for that history. So what is the biggest complaint you receive about your election process? Insufficient, lack of notice, lack of candidates, good standing issues, and proxy or ballot issues, all of which we'll be talking about during the rest of this webinar. Okay. So predominantly lack of candidates, and then next would be proxy or ballot issues. So those are the main issues that people are facing. Okay, so our next speaker now is Ron Pearl to continue on to discuss the legislation.
Thank you. Good afternoon, everyone. Hill Wallack is pleased to present this webinar in conjunction with Wilkin Guttenplan, and we thank them for their participation. The next two segments of the presentation are intended to highlight the specific requirements of the legislation, hopefully in a way that will allow you to feel more comfortable working with it. For community managers, our hope is that you will be able to discuss it with your boards and use it as you prepare for elections this fall and thereafter. As Caroline has said, this program is for general information about the new law, and we encourage you to seek the advice of counsel as you implement this for the first time. One of the substantive changes and main purpose of the law has to do with eligibility to serve on an association's governing board. The Radburn Association had severely limited the ability of most homeowners to serve on the governing board. It was this inability to participate directly in the governance of the association that led to litigation and ultimately this legislative change. The result is that any member in good standing may run for and serve on the governing board of a community association. Members in good standing may nominate themselves or another person. They may vote and serve on the governing board. The definition of good standing is contained in the law as well and goes beyond what you might normally expect. The expected part of the definition is the requirement that a member be current in paying their common expenses, late fees, interest, legal fees, or other charges that are lawfully assessed. What you might not expect is that a member who owes money to the association may be in good standing. Why? Because a member is in good standing if he or she is in full compliance with a payment plan or settlement agreement to pay past due assessments or other charges, or if the member has disputed the charges and that dispute is not resolved. An unresolved dispute means that there is a pending ADR or pending litigation concerning the disputed charges. In our opinion, requesting ADR in accordance with an association's valid ADR procedure creates or begins a pending ADR. It is not necessary that the ADR procedure actually be scheduled. It just needs to be validly requested. The purpose behind this provision of the law is to protect owners who are subjected to assessments or other charges which the member feels are wrongfully imposed. While the issue is being resolved, the owner retains the rights of membership. This seems to be a fair balancing of interests, since the effect on the individual member of the loss of a vote and/or eligibility is probably greater than the effect on the association. In any event, the current status of the law is that the member retains good standing while those issues are being resolved. Another interesting twist is that for purposes of running for office and voting, being in compliance with the rules is not part of the good standing requirement. I know that some documents define good standing as being current in assessments and not having any pending violations. That kind of limitation is no longer valid for purposes of election and voting. Another issue that arises in associations frequently is the question of whether members of the same household, for example, a wife and husband, may both serve on the board at the same time. The proponents say that apathy makes it difficult to fill board seats and that it's sometimes necessary to have more than one representative from a single home. Others argue that each co-owner is a separate person who is entitled to serve on the board. On the other side of the argument is that it makes one family too powerful because the spouses or other co-owners will have the same views and vote together on important issues. This legislation permits bylaw provisions that prohibit more than one person serving on the board from each unit or home at the same time. This is an exception to the general requirement of the law that each member in good standing is entitled to serve on the board. But unless it is in the governing documents that only one person per unit may serve at the same time, each member in good standing is entitled to serve. Terms of office. The legislature had a concern with long terms of office and the frequency or lack of frequency of board elections. It therefore added a new section dealing with board elections. That section mandates that elections must be conducted in accordance with the governing documents unless they conflict with the provisions of the new law. If the documents do not contain a specific interval between elections, they must be held at least every 2 years. If an association hasn't been holding elections as required by the governing documents, it must hold an election within 90 days of receipt of a petition signed by at least 25% of the members in good standing. In other words, for boards that don't conduct elections in accordance with the governing documents, a petition of the members may request them, and if you get 25% of the members in good standing signing such a petition, the board must hold an election. The association must conduct one within 90 days of receipt of the petition. The 90 days starts when the petition is received by any current board member. It doesn't have to be the secretary, president, or any other specific officer. It can be given to any sitting board member. If the petition is ignored, any member or group of members may petition a court for authority to act temporarily on behalf of the association and conduct an election within 90 days of the court order. This means that the member or group of members will take the place of the board for purposes of conducting the election. Yes, that includes collecting and counting ballots. The law uses the term organize and hold an election. And in our opinion, it includes everything from the notices through certifying the count. So if you are a board member or managing agent and you have not held an election as required by your documents, you need to promptly schedule the election or the matter might be taken out of your hands. This new section on elections differentiates between associations having fewer than 50 units and those having more than 50 units. For the smaller associations, there are no specific timeframes or detailed requirements. The requirement is rather somewhat general, but it does include certain requirements for those smaller associations. Those associations must ensure a system where there is notice, ability to nominate, and vote for any member in good standing. Must be transparent requirements and clear qualifications to run for the board. There must be ready access to information on when and how to vote. And last, a process for the counting of ballots and verification of eligibility to vote. The law mandates that all steps of this election system must be conducted in a non-fraudulent manner. The requirements for larger associations over 50 units are more specific. Terms of office are limited to 4 years, although there are no limits on the number of terms that a person may serve. Also, a board member may serve until his or her successor is duly qualified and elected. If your bylaws do not specify an interval between elections, meaning the frequency of the elections, an election must be conducted every 2 years. If your documents say that elections are to be held every year, then an election must be held every year. I will point out that because the maximum term of office is 4 years, if your documents provide a longer interval between elections, the 4 years will apply. But there aren't too many documents, if any, that specify that long of an interval between elections. All members in good standing have the right to nominate themselves or nominate other members in good standing. A notice to this effect, which is essentially a call for candidates, must be sent to all members at least 30 days prior to the mailing of the official notice of meeting. The association must allow at least 14 days for the members to respond to the call for candidates. We'll discuss overall timing in a minute. Notice of meeting. The notice of the election meeting must be sent at least 14 days, but not more than 60 days prior to the meeting. This will be consistent with most existing governing documents. I've rarely seen documents that don't already have notice requirements within this range. As far as methods of notification, it must be accomplished by personal delivery, mail, or by electronic means, although electronic communications may be used only if permitted by the governing documents or agreed to by a member in writing. In order to implement this, I would suggest distributing forms to each owner, asking them to consent to electronic notice of meetings and electronic voting. To me, one of the most beneficial and exciting parts of this legislation is the adoption of electronic communications and voting. For years, publicly traded companies have used electronic notice and voting quite successfully, saving both dollars and time and gaining efficiency and participation. There are companies that conduct voting by electronic means and, if done properly, provide for verification and security. I've been amending documents for clients over the past couple of years to permit electronic notice and voting when the law is changed to permit it. Now it's been changed to permit it. And now that the law does allow electronic voting and notice, those provisions will be activated and those associations will be immediately able to employ the electronic alternative. By the way, when I have done these amendments, they have all contained an opt-out provision for individuals who cannot or choose not to use the electronic process. I would encourage all associations to explore this possibility and pursue amendments and/or member consent, as it represents an important advance in our industry. The next slide shows a sample timeline. It represents a relatively short timeline using the minimum requirements of the law. It's merely intended to illustrate that you will really need to think ahead and begin the process of scheduling elections, perhaps earlier than in the past. Here we've worked back from a November 14th election. If you look at the calendar, you'll see that some of the dates fall on a weekend, so remember, these are for illustration purposes only. And what this illustrates is that you pretty much need to get started in early September for a mid-November meeting. In our example, the call for nominations goes out September 17th. You must send that out 30 days prior to the mailing of the election notice. Allowing 14 days for the nominations to be made brings us to September 30th. But you could allow more than 14 days if that works better for you. You must allow at least 14 days. In the illustration, the notice of meeting goes out October 16th, which is the required 30 days after the call for nominations. This notice must include proxies if authorized and absentee ballots. If your documents do not authorize proxies, obviously you can't use them. But if they do, the notice must include proxies and absentee ballots. Jonathan will talk more about this in a couple of minutes. In our illustration, we've chosen to give 30 days notice of the meeting because in our experience, that is a common time period. So the meeting will be November 14th. Here's the tricky point. The law says that even if you set a deadline, nominations must be accepted up until the day before the mailing of the notice of meeting. The mailing, by the way, cannot occur until one day after the nomination period ends. This creates practical issues. If a 1,500 homeowners association has all the notices printed and stuffed in envelopes with postage on them the day before the mailing, and then a new nomination comes in, do you then have to throw away all those ballots and envelopes? My personal opinion is that if you are in a larger association, you should set a deadline consistent with the law, and in the normal course, if you have the ballots printed and are in the process of mailing and a late nomination comes in, you would have a good argument that you are in compliance. But I can't guarantee that because the law says that you must accept a nomination, quote, so long as the nomination is made prior to the mailing of ballots or proxies to the association members, end quote. The practice tip here is that you should mail at least a few notices and ballots, even in a large association, the same day as the notices, proxies, and absentee ballots are printed. Therefore, the process of mailing has been started, and you don't have to worry about nominations coming in. Before I pass this off to Jonathan, I want to mention the concept of a voting eligible tenant, the definition of which is on the current slide, as well as certain kinds of associations which contain voting systems that are specifically permitted under this law. First, tenants. You won't run into many governing documents which permit tenants to vote, but this law recognizes the concept and opens the possibility for associations to amend their docs to allow tenants to participate in the governance of associations, or for developers to include the concept in new projects. Whether this is good or bad is not part of our discussion today, but just understand the possibility now exists. Finally, there are 4 situations specifically permitted by law in which boards may be elected other than by direct proportional vote of the members. I just want to mention them as that we don't have time for a full discussion. In a mixed-use development, you can have certain board seats reserved for different uses. The most common example is the commercial-residential combination, where certain seats are assigned to commercial owners and others to the residential. That's permitted. You may also have combinations of other uses, and a board where seats are assigned to each different use is permissible. The second situation involves affordable housing, where affordable units make up a minority of the community, but certain board seats are reserved for those units to assure representation of the affordable owners. This is permissible as well. Also permitted is voting by section, where a development is divided geographically and each section is permitted to nominate candidates for and vote for certain seats on the board. The one requirement in these situations, except for the affordable housing, is that the voting weight must be approximately proportional to the number, value, or size of units. With that, I will turn it over to Jonathan.
Thanks, Ron. Before we get into the new requirements, let's start with a brief discussion of what proxies are and what absentee ballots are. A proxy is not a method of voting. Rather, a proxy is a grant of authority by an owner, member, or voter to a representative or agent to vote on behalf of the member. A proxy may be used as allowable by law and pursuant to an association's governing documents. An absentee ballot, also called a mail ballot, is a written ballot that may be cast by a voter without attending the meeting and may be mailed or otherwise transmitted to the association. You may also have heard the term directed proxy or proxy ballot, which is essentially a proxy that instructs the proxy holder how to vote on a specific question or who to vote for in an election. The difference between a straight proxy and a directed proxy or proxy ballot is that a straight proxy does not instruct the holder of the proxy how to vote, but rather gives the person the authority to vote on another's behalf based on how the holder of the proxy wants to vote. The proxy system comes from the corporate world, but has worked its way into the association governance. Most governing documents will allow voting either in person or by proxy, so it is something that most associations are required to offer pursuant to their specific documents. So, with that knowledge, let's look at the provisions of the new legislation pertaining to proxies and absentee ballots. If your governing documents allow for proxy voting, you must now offer absentee ballots, as Ron previously mentioned. Some governing documents only allow for voting in person or by proxy, so in those cases, the option to vote by absentee ballot must now be made available to all of the members in good standing. Also, and this is a little confusing, but the language of the new legislation, specifically in Section 6C5, says the notice of election shall include a proxy ballot and an absentee ballot unless prohibited by the bylaws. Again, not only is this confusing, but it's duplicative to provide both a proxy ballot and an absentee ballot. So as a practical matter, we recommend just sending a straight proxy and an absentee ballot. Sending a directed proxy or a proxy ballot and an absentee ballot will just create confusion among the members. However, because of the complexity of this issue, boards should definitely discuss this with their counsel to ensure compliance with the new requirements. Also, as mentioned previously, proxies are an authorization for someone to vote on the member's behalf. Directed proxies or proxy ballots appoint a representative to vote in a specific manner. And then absentee ballots are a direct vote submitted in lieu of attendance at the meeting. Also, proxies must contain prominent notice that the use of the proxy is voluntary and that it may be revoked at any time before the proxy holder casts his or her vote. So generally, proxies may be revoked, while absentee ballots may not be revoked. Moving on to voting procedures. All election ballots are required to list the names of all candidates nominated in alphabetical order by last name. We have seen elections where sometimes the current board members were listed first, or there was some other method to determine placement on the ballot. That is now prohibited by the new law. Interestingly, we have also seen where some associations will list current board members as incumbents on the ballot. There is no prohibition to doing that in the new law, and it would be allowable unless your specific governing documents or election rules prohibit it. Associations may now utilize electronic voting, as mentioned previously, when authorized by the governing documents or when an association member consents to casting a vote electronically. As Ron mentioned in his portion of the presentation, it bears repeating, electronic voting is a ballot that is cast online or through other electronic means without attending the meeting, delivered directly to the association through a website, email, or other secure program prior to the meeting. It is, in essence, an absentee or mail ballot that is transmitted electronically. This is one of the more overlooked provisions in this new legislation, in that it now provides statutory authority for New Jersey community associations to vote electronically. While this issue may not have come up previously in many associations, many states' nonprofit corporate statutes or association enabling statutes do not specifically address and/or authorize the option of electronic voting. In addition, most corporate statutes provide that elections or other action can be taken only at an in-person meeting of the members or if no meeting is held by unanimous consent. For example, New Jersey's Nonprofit Corporations Act provides only that the election of trustees may be conducted by mail, and the Act authorizes decisions to be made in lieu of an in-person meeting only if all members entitled to vote consent thereto in writing. There is no mention of voting by electronic means. Again, the new law now specifically authorizes a community association to utilize electronic voting. Please note, however, as mentioned before, electronic voting does not mean an association or its management can just accept ballots by email. Rather, electronic voting means that ballots are cast online or through other electronic means without attending the meeting and delivered directly to the association through a website or other secure service or program prior to the meeting. Also, the association cannot make electronic voting the sole means to vote. It still has to offer other methods of voting pursuant to a document, which would be either in person or by proxy. And finally, on this point, we would recommend an amendment to your association bylaws, as Ron had previously suggested, if you are considering allowing for electronic voting within your association. We're now going to move to our third and final polling question.
Okay, just before I read that, I just want to remind everybody, if you do have questions, please feel free to type them in the question pane. We will be holding them until the end, and we'll be answering them when, at the end of the presentation, when John's done talking. Okay, so the next question is, prior to this legislation, what was the voting requirement to adopt an amendment to your bylaws? Simple majority, 2/3, greater than 2/3, no amendment provision, or you don't know. Okay, so it looks pretty much like the majority of you have that 2/3 is required. Some do have simple majority, and of course a few of you don't quite know. But the majority, it looks like, is 2/3. Okay. Thanks, John.
All right, great. So with that question in the books, we're going to move on to amendments to the bylaws. So this section in particular has created a lot of discussion and debate. So I'll ask that you stick with me here while we try to go through the new requirements. If your bylaws require a vote of 2/3 or less to amend, the new legislation does not change those provisions. However, if your bylaws have no amendment provision, or if more than a 2/3 is required to amend the bylaws, that provision is no longer valid and the law substitute a new requirement. The bylaws may now be adopted by an affirmative vote of the majority of the total authorized votes in an association. And I'll say that again so everybody understands it. If your bylaws currently require over 2/3 vote to amend, or if there is no provision to amend, that is no longer valid. Instead, that provision is now replaced and the bylaws in those associations may now be amended by a simple majority of the total authorized votes. Total authorized votes is defined in the legislation as the total number of units minus any members who are ineligible to vote because they are not in good standing in accordance with the provisions that Ron spoke about previously. So essentially, amendments will now be allowable if 51% of the owners in good standing vote in favor of the amendment. The next provision talks about when the board can make amendments to the bylaws without an affirmative vote. And what that says is the new legislation can allow an association's board to amend the bylaws without a vote of the members if necessary to render the bylaws consistent with the state, federal, or local law, or if a ballot provided to the members to reject a proposed amendment fails to receive at least 10% of the vote within 30 days. So if the bylaws are in conflict with the current law, the board can amend without putting that question to the members. Also, there is now this amendment by rejection provision, which is almost a backwards way for the board to be able to amend without the affirmative vote of the owners. In essence, this should make it easier for some boards to amend their bylaws for certain non-controversial issues. The reason we say that this new legislation can be interpreted in this way is because there are some attorneys interpreting this section only to apply when your bylaws currently require over the 2/3 requirement or if there's no provision to amend. However, we do not read this provision to restrict it only to those associations, and we believe it applies to all associations. That being said, and you've heard this before, because it is somewhat unclear as to how this provision will be interpreted in the future, we strongly recommend that you consult with your association's counsel before attempting to amend using one of those provisions. Also, you need to remember, this amendment provision refers only to an association's bylaws. It does not refer to amendments to the master deed or to a declaration. The effective date. The effective date of this law, as discussed previously, is July 13th, 2017. So the majority of the provisions in the new law have already taken effect. However, there is a grace period for the election notice provisions, which does not go into effect until October 1st. So in terms of upcoming elections, you're going to need to start the process earlier, as in 75 to 90 days earlier, so the new provisions will apply to elections after October 1st. So what does this mean for my association? Again, this legislation amends and supplements the provisions of the Planned Real Estate Development Full Disclosure Act. To the extent that the requirements of this legislation conflict with the association's bylaws, the new provisions will trump the requirements of those bylaws. And most importantly, all owners within an association must now be considered members of that association with the ability to fully participate in elections of the boards, including the ability to both run for and vote for members of the board, so long as they remain in good standing. We're going to be finishing up and taking questions in a minute, but I wanted to remind everyone that you can find the information we spoke about today and much more on our blog at www.condolawnj.com, and you can also follow us on Twitter at New Jersey Condo Law.
Okay, thank you very much. So we do have a number of questions that came in. So I'll read the questions, and then one of you can feel free to jump in and answer. All right, so the first is, when is this effective? So this question relates to the terms. If there's a board member who has been on the board for 5 years, does the board need to hold an election immediately, or do they have 4 years from now to start?
Well, why don't I take that? The limitation on terms of office, I believe, begins when the law becomes effective. So somebody that was elected prior to this law and who has a term in excess of 4 years can serve out that term. But the problem is the question doesn't specify whether the person was elected to a term of 5 years or more, or is just serving multiple terms adding up to. You can serve multiple terms without limit. So the person may be on the board for 10 years with 5 2-year terms, and there's no problem with it. The other answer to this question relates to the duration of time between elections. If this person's been on the board for 5 years because you haven't had an election in more than 5 years, you better hold an election. So there's really a couple of answers to the question. I hope that adequately addresses it.
Okay, so really it's not, you don't just look at years by itself, you look at the term.
You look at the term of office, yes.
Okay, all right. So the another question that came in, Does the consent for electronic process require 2/3 of community approval, or just per unit owner, that a unit owner can do it or not do it?
Yeah, the answer is both. You can, when you have a group of owners who would prefer to get notices electronically and vote electronically, and they do exist because we've been asked all the time, can we do our voting electronically? Can we do electronic notices? If owners consent on an individual basis, it is permissible. So that's when I suggested to send out a form to everybody and see who will consent in writing to receive electronic notices and who will vote electronically. But I also say yes to the 2/3 because the law does allow associations to amend their governing documents to provide for electronic voting. The one caveat where you amend your documents to allow electronic voting, you must also, under this law, provide for alternative means by absentee ballot or proxy. So you can't amend your documents to provide only for electronic voting as the sole means of voting or receiving notice in an association. You must provide those alternatives if you amend your documents.
Okay. We're just going to backtrack a minute. The first question that Ron, that you responded to with regard to the terms, there is a follow-up question on that, and that is that do board members need to have 1 year off the board between terms?
Not for legal reasons. They may need to recuperate, but the law does not require that there be a break in terms.
Okay. All right. So do we need, another question, do we need to send proxy and absentee ballots, or can we just send absentee ballots?
So the new law says that if you are offering proxies, you must send both a proxy and an absentee ballot. As we mentioned in the presentation, the actual language of the law says proxy ballot, and we know a lot of our associations will send what's called a proxy ballot or a directed proxy. In order to be compliant in the new law, what we recommend is that we're just sending a straight proxy as well as an absentee ballot, just so there's no confusion.
Right, but you do have to send both. You have to send a proxy and an absentee ballot if your documents authorize proxies.
Okay, so kind of as a follow-up on that, John, can you explain the difference between a directed proxy versus an absentee ballot, or the use of non-directed proxies, and what should be used?
Right, so again, like we talked about, the easiest way to do it that we see going forward is to send a proxy, which again, the proxy is giving the authorization for a member to allow somebody else to vote on their behalf, and also an absentee ballot. A directed proxy is a proxy, again, authorizing someone to vote, but then directing that person how you would like to vote. Again, sometimes that's called a directed proxy, sometimes it's called a proxy ballot. Because this is confusing, again, we're going to recommend that you speak to your association counsel when preparing these documents. But for purposes of the new law, it does require that if your documents authorize you to allow voting by proxy, you now also have to send out and allow absentee ballots.
Okay. Another question coming in. This association has a provision that limits board membership to resident owners. Therefore, travel expenses is not a consideration. If they incorporate an amendment that prevents board members from submitting travel expenses, does this amendment need to be voted on by all members, or can be done just by the board because it's a result of the new law?
Well, the new law doesn't address travel expenses. The new law says that you can't allow only resident members to be elected to the board. All members in good standing are entitled to be on the board, and they can live in Hawaii. If your documents contain a provision saying that you must reimburse travel expenses, and you want to amend that out of it because you do have somebody that puts in for airfare from Hawaii, that is permissible to do. And we mentioned a couple of ways. If your documents say that you need 2/3 of the members, then you need a 2/3 vote to amend. If it contains a greater requirement, or none at all, then it's the lower amount, 50%, 51% of the members entitled to vote. And then there's this other way that John described, which essentially allows the board to amend and then present the question to the members. And if fewer than 10% of the members reject it, then it becomes a bylaw amendment. Again, we believe that that applies across the board for all associations. Some may differ. Consult with your own attorney. But I would not say that an amendment to a reimbursement, a travel reimbursement, is made in that first part of the what I'll call the negative amendment process, because there is no requirement in this law that you eliminate travel expenses. So it is not an amendment that would qualify to comply with the law, but you could still, in our opinion, use that, I would guess, negative amendment process.
And if I may, one of the questions that I've received a few times is whether or not this law changes the quorum requirement section of your bylaws. So if that section states that you have to have a quorum of X% in person or by proxy, the ability to utilize absentee ballots for voting purposes does not change the quorum requirement.
Okay. There's a another follow-up question that just came in, so we'll go to that now. So if someone's an owner and wants to be on the board, but they live out of state, does the board have to make accommodations for their participation, such as dial-in or conference calls, so that they can, in fact, participate?
Well, the board member has an obligation to participate in meetings, and so it's really the board member's issue. If the board member can't comply with the requirements of board service, then maybe that person shouldn't be a board member. But that's the board member's decision and a decision of the voters. I will say that the New Jersey law, which allows participation by conference telephone, where everybody can hear one another and speak to one another, is a very convenient provision in the nonprofit corporation law, and it's very easy to implement. So in many of our 55 and older active adult communities, when the snowbirds head to Florida or Arizona for the winter, it makes it possible for them to participate. And in fact, we even use Skype because it has the same ability that people can hear and speak to one another. So I hope I've answered the question. It's not all that simple. The simplest thing to do is just to put a conference telephone in the room, let them participate.
Okay. Is there a new cutoff date for good standing?
That's a really good question. Some documents say that the definition of good standing is, for example, that a person has to be current in their financial obligations 10 days or 5 days prior to the election. So this law would supersede it. This law says that if you're in good standing as defined in the law at the time of the nomination process, you're entitled to be nominated. And, you know, if you are in good standing at the time of the election and have been nominated, you're entitled to serve.
What happens if the bylaws state that the owner must also not be in violation of any rule or regulation to be in good standing?
As previously discussed, we believe that that particular requirement is no longer valid, that the good standing definition is based solely on the person being current in the payment of any assessments or other charges to the association.
That's good standing with regard to elections and
Correct.
voting.
Correct.
Yeah.
Now, what happens if a board member becomes delinquent while they're serving on the board?
If that happens, you would have to refer to the individual bylaws. The legislature does not address that. You would need to refer to the bylaws of the association.
Okay. If an owner owns 2 units, can they occupy 2 board seats? So let's say, you know, I'm assuming a husband and a wife, or a person, or just 2 people that are living there, that they own 2 units. can they occupy 2 board seats?
Well, each member in good standing is entitled to occupy 1 seat. One person can't occupy 2 seats, and this law doesn't change that. A board seat, you're eligible for a board seat if you're a member in good standing, but that doesn't mean that you get 1 board seat for each unit that you own. I've never seen a set of governing documents that says that. You get a vote for each unit that you own, but you don't get the ability to serve on the board for each unit that you own.
So you can't hold 2 seats.
But if a husband and wife owns 2 units, then even if you had a bylaw provision saying that only 1 person from a given unit could serve at the same time, they could be elected 1 from each unit. So that's another little twist. But
okay. Just we've been talking a lot in here, and we've mentioned condominium associations, homeowner associations. Just to clarify, are co-ops also affected by this legislation? Are they part of this?
Yes, they are.
Okay. That's a quick and easy answer. All right. Back to absentee ballots. So are they to be made available on request or just sent to everybody?
So again, what the law says is that now, again, if you offer proxies, you must also offer absentee ballots, and it says that it must be mailed with the election notice.
Okay. All right. Thank you. Okay, another one's coming in. With all of these recent changes to the law, how are they incorporated in the bylaws if the bylaws do not need to be amended to incorporate the new law?
well, first of all, the law is going to the extent it contradicts the current bylaws, the law will apply. So if you had bylaws that say each member of the board serves for a 5-year term, that's no longer going to be valid. However, it's very easy for the board now under the provision that Jonathan discussed to amend the bylaws to comply with the law. So I would recommend that you do that because you have recorded bylaws, you might as well make them consistent with the law, and this is a very good opportunity to do that.
Okay. So, the legislation, the DCA's role in this, is the DCA enforcing these requirements?
The DCA does not have any statutory authority to enforce these particular requirements. There are other requirements that they do have the authority to enforce, and you can determine what those areas are by going to the DCA website. They include open meetings and so on, and ADR. But I will say this, I've noticed that the DCA has published a document that is called Guidelines for the Radburn legislation. And I'll point out 2 things. Number one, they are not binding as a regulation. The law didn't give the DCA the authority to promulgate regulations to carry out the purposes of the Radburn legislation. And so those guidelines are not binding law. And secondly, please discuss them with your lawyer before relying on them because this is just a personal comment. Some of the contents I couldn't find in the law itself. So you may want to consult with your attorney before implementing those DCA guidelines.
Okay. All right. Thank you. So is the requirement to have a nominating committee still valid? Has that been addressed?
The idea of nominating committee wasn't touched by this legislation. You can have a nominating committee, and we do in several of our associations, but they don't get to choose the candidates anymore. What they can do, however, is receive the self-nomination forms or the nomination forms for other members in good standing. They can verify that they are members and that they are in good standing. They can do things like publish the biographies of the candidates or the candidate profiles that many of them do. Many nominating committees run a candidates night. So you can have a functioning nominating committee. They have just lost their job in terms of being able to nominate the candidates.
Okay. So we've talked about e-voting. Can we just clarify quickly again what the law requires with regard to e-voting? Just so we're clear on that.
So just to make it simple, if an association wants electronic voting, it can amend its bylaws to provide for a system of electronic notice and voting, or it can now offer electronic voting as an option to those members who wish to participate. But as Ron stated previously, you have to offer an additional way. It can't just be electronic voting. You have to also offer either in person at the meeting or by proxy or by absentee ballot.
Okay. All right, well, we've pretty much run out of time. So I want to thank everybody for listening in. We appreciate your participation in this important webinar. You have our contact information. If there's other questions that you have, please feel free to contact any of us and we'll try to get back to you. Again, you will be receiving an email from us so that we can give you credit if you did want the credit for property manager classes. And you can also see the recording again at our website. So that's www.wgcpas.com. So thank you very much, everybody, and we appreciate your time.